Good morning. This is an audio and visual test to see if I'm working in the interwebs.
Yes, I can hear and see you.
Thank you so much, and we'll do this with
Welcome.
goodness here in a little bit. Thank you.
Sure.
This is a test just to make sure my audio and video are working.
Yes, I can hear and see you.
Excellent, thank you.
Welcome.
Good morning. This is an audio test.
Good morning. I can hear and see you.
Thank you so much.
Welcome.
All right. Hey, Harry, can you hear me?
Yes, I can.
All righty. We shall go on the record with proceeding number 24AL-0497E in the matter of advice letter number 1970, electric filed by Public Service Company of Colorado to revise its solar rewards community service tariff effective January 1st, 2025. I'm Administrative Law Judge Robert Garvey. Today is the 29th of May, 2025 at 9 a.m. This comes on for an evidentiary hearing. I will start with appearances and go company, interveners, and then staff.
Good morning. My name is Tyler Mansholt, representing Public Service Company of Colorado.
Good morning, Mr. Mansholt. Haven't seen you for a while. Good to see you again.
Likewise.
Good morning, ALJ Garvey. Ellen Howard Coots are here on behalf of the Colorado Solar and Storage Association, the Solar Energy Industries Association, and the Coalition for Community Solar Access. We are again calling ourselves the Joint Solar Parties.
All right. And good to see you again. It's been a couple of weeks, but thank you. And
Good
staff.
morning. Thank you. Jennifer Hayden, Assistant Attorney General with the Colorado Department of Law, representing trial staff.
All right. Good morning, Ms. Hayden.
Good morning.
Real quickly, the spreadsheet, which is labeled as Exhibit 500, should have been to everybody. I won't go through the whole deal, but is there any objection to spreadsheet 500 spreadsheet Exhibit 500 being entered into evidence? Don't see anything. I don't think I've got any preliminary matters other than that. Does anyone have any preliminary matters before we get going? I don't see anyone having. How about that? We're going to get started at 9:02. Public service, you may call your first witness.
We call Mr. Neil Cohen to the stand.
All right, Mr. Cohen, raise your right hand for me. You swear affirm, tell the whole truth, nothing but the truth under penalty of perjury.
I do.
All righty, go right ahead.
Can you please state and spell your name for the record, Mr. Cohen?
Yes, my full name is Robert Neil Cowan. That's Cowan. I go by Neil, hence the initial R in my testimony.
And what is your role and what company do you work for?
I am a manager of regulatory policy and employed by Public Service Company of Colorado.
And did you sponsor in this proceeding here in Exhibit 100 Rev 1 and here in Exhibit 102?
I did.
Do you have any material corrections to those testimonies you are aware of?
I have no corrections.
Well, we'd ask to enter those exhibits into the record and then allow Mr. Cowan to be available for cross.
Your Honor, I think you're on mute.
Sorry, I was afraid my dog was going to bark. Those are entered into the record, and Ms. Christie, you may start with the cross-examination.
All right, thank you. Good morning, Mr. Cowan. How are you this morning?
I'm doing well. How are you doing?
I'm doing well as well. This may be a little bit repetitive for ALJ Garvey, so I will try to keep things quick and narrow today. Let's start off and level set about this case. Mr. Cowan, do you agree with me that there are 2 remaining key issues in this case related to the fixed bill credit calculation?
Yes, there are 2.
And just to level set, one of those issues is the number of vintages that are required to be filed in the utilities tariff, correct?
Correct.
And the other issue is the potential adjustment mechanism that applies to the fixed bill credit, correct?
Correct.
And would you agree with me that the fixed bill credit requirements are driven by the language that was adopted in House Bill 231137, as well as the Commission's electric rules implementing House Bill 231137?
Yes.
And can we also agree that the Commission's order adopting the rules implementing House Bill 231137 is instructive as to how the Commission envisioned the fixed bill credit methodology should be adopted?
Yes, and I believe that's what the decision in 24R-0133E, correct? I
That
think
sounds that sounds
sorry.
like the right number. I'll take your word for it.
Yeah.
All right, great. Let's take a look here at Excel's position on what the Commission has to do in this proceeding. Could we please pull up Hearing Exhibit 100, specifically page 6? All right, so if we could scroll down to line 11, excuse me. Mr. Cowan, you recognize this as your direct testimony, correct?
Yes.
Okay, great. So here you are providing a citation to the Commission's order that you and I just discussed, and the statute, which was adopted in House Bill 231137, requiring the fixed bill credit methodology, correct?
Let me just reacquaint myself.
Sure, go right ahead.
And you're going through the whole queue. Am I understanding your question correctly? The whole queue?
Yeah, if I may have bungled that question, I'm really just level setting what you're speaking to here in this portion of your testimony, and I'll be asking you questions about the entirety of this Q&A if you want to refresh your memory about it.
Yeah, I'll answer your question. That's the statutory reference, and the Commission did address that in the aforementioned docket 24R-0133E.
And would you mind reading for ALJ Garvey in the court the testimony you have here starting at line 1, that sentence?
Which line again?
Line 21.
21. The Commission rejected the consensus approach, favoring said an approach that deferred resolution of whether and how to consider the change in value over time through utility annual November 15th bill credit tariff filings.
Perfect. Thank you, Mr. Cowan. So again, just to level set, that's this proceeding that we're in right now. That's this tariff proceeding.
I would specify this is one of those proceedings. We make those every year.
Great. So would you agree with me that in this language that you've put forward, the Commission has directed parties to perform this exercise annually? In other words, we're going to do this every year.
I believe that our interpretation of that is that this is the vehicle by which this can happen, an adjustment mechanism that can happen. And I would add further detail that being that the advice letter that we filed in November 15th of 2024 was the first one after that NOPR proceeding.
Great. So just to level set here, in this proceeding, really, the Commission really only needs to make a decision about how the 2025 bill credit, the 2024 bill credit, and the 2023 bill credit are adjusted, correct?
Well, as filed, it was about the 2025 build credit and the, increase, decrease those build credits. Again, we make these
Great.
tariff filings every year. Through our direct case here, you mentioned going
That's-
back to 2023.
You can address that with counsel on redirect, but that was my question. So we're deciding about those 3 vintage credits. Thank you.
Objection, that's mischaracterizes the witness's testimony.
I think it kind of does. I'm gonna sustain that objection.
Happy to withdraw my restatement of the witness's testimony from the record, Your Honor.
Yeah. I mean, I think his testimony is that we're doing it for 23, 25, and I forget the third year, but not necessarily adjusting those years.
Yes, I would agree. I apologize. I apologize. You are correct.
Yeah.
Okay, let's move on and talk about the vintage years. So just to be clear, because this is a little bit different between the 2 utility cases, in this proceeding, Excel has conceded that the vintage years that should apply in this tariff for the fixed bill credit should start in 2023 and include 2024 and 2025, correct?
Yeah, we adjusted from our position from our original filing to include going back to 2023, as that is the year in which the House Bill 23-1137 was signed into law.
Perfect.
We believe that's a reasonable approach.
Okay, great. Let's move on and talk about the adjustment mechanism itself. So it's correct to state that the company does not support a consumer protection index adjustment mechanism, correct?
Correct. We do not support that.
And in your rebuttal testimony, which I'm happy to pull up if we need it, and we could take this down too if needed, you put forward a statutory interpretation about why you don't support CPI, correct?
Correct.
And one of the things that you claim, maybe let's go ahead and pull that up just so we've got it. It's hearing exhibit 102, page 9. And apologies, I messed up and didn't put the pin site. So here, starting on line 1, you're basically stating that the legislature expressly authorized a consumer protection adjustment mechanism in a different section of the statute, which relates to interconnection penalties, but it failed to do so here as it relates to the fixed bill credit methodology in 42-127 5B2E. And you conclude here, last sentence of the paragraph, lines 5 through 6. If the legislature wanted the commission to apply a CP adjustment, it would have required that expressly, like it would have required like it did in 40-2-135 2B. Did I barely read that correctly, Mr. Cowan?
Yeah, the interconnection penalties specify that as a CPI adjustment, and it is not present a CPI, an express statement or express direction is not present in the statute from House Bill 23-1137.
But do you and I agree that in the statute that was passed, happy to pull it up if needed, there is a requirement for the commission to consider the change of value to community solar gardens customers of the fixed bill credit over time through rate adjustments and other mechanisms?
And the commission considered that in its NOPR.
Okay, but we'll get to that in a second. The legislature has directed the commission to consider an adjustment mechanism, correct? We agree about that.
Yes, and again, I will say that they did consider it in the NOPR. That was a consideration.
Okay, great. Would you and I agree that, well, let me level set. So you've been working on Excel's regulatory team for quite some time, isn't that correct, Mr. Cowan?
That is correct.
So you're generally familiar with the Commission's regulation of public service, correct?
Yes, I am.
Do we agree that the Commission has broad constitutional and legislative authority to make decisions about how public service is regulated?
Yes.
And so even if something is not expressly authorized by statute, the Commission has authority to consider other mechanisms, in this case, to adjust that fixed bill credit methodology, correct?
And answering that, I would again point you to the consideration was made in the NOPR and effectuated in their decision based on that NOPR.
Understand your position about the NOPR. What I'm asking is, like, the Commission has this broad authority and it can make this consideration. We agree about that.
The statute says what it says in terms of their consideration of how to effectuate or how to evaluate the value.
So putting aside your and I difference about the NOPR and what did or didn't happen in the NOPR, hypothetically, the Commission could order a CPI, an adjustment mechanism, and that's within its authority. We agree?
But I don't think there's statutory foundation to consider CPI. It's not stated in statute.
But the Commission has that authority.
They could.
Great. So let's move on and take a look at hearing exhibit 102 here, page 9, line 9. And here you state the company has concerns that imposing an inflation-based adjustment mechanism such as the CPI is arbitrary and will unreasonably distort the CSG fixed bill credit. Did I read that correctly?
Yes, we have concerns with that. Yes.
Is it your position that imposing an inflation-based adjustment mechanism is arbitrary in all regulatory contexts?
I'll respond by saying that there has to be a foundation and there has to be context. CSG bill credits are based on system costs, and to implement something like a CPI, which I believe the joint solar parties have provided one, which has basically a compounding interest impact, should be seriously considered. And it's actually a little bit concerning, as the cost of those CSGs will be borne by ratepayers.
Mr. Cowan, respectfully, that wasn't my question. What I asked you is your position, or is it the company's position, that imposing an inflation-based adjustment mechanism is arbitrary in all contexts?
Again, I'll respond by saying that the context matters on how that is implemented. And I don't believe that there is context or foundation in this context to do so.
Understand that position. So let's take a look at the company's use of inflationary adjustment mechanisms in those other contexts. Could we please pull down this exhibit and turn to what's been pre-marked in box.com as hearing exhibit 301? Ooh, and let me...
Sorry, it's just taking a second to open that one.
Yeah, I may have mislabeled things here too. I apologize for that. Shoot. I may have mislabeled things, and it's going to affect a few things in box.com. I'm not sure how to address that. So I apologize for the delay here and for that mistake. So what I have is now I have 2 301s in the box, and I'm happy to take a moment and fix those, or we could fix them in real time. I sincerely apologize for that.
Sorry, that actually might be why it's not opening. Let me go into the web version of Box instead of my file manager. Do you know what it's titled? Which one you're looking for?
Yeah, so...
Can I go off the record for this then?
Yeah, absolutely, Harry. Yeah, go off the record.
so sorry about this. So the one that
Well,
I'm
hang on. How long do you think this will take to fix? Just real quick, Stephanie, if you know, let's go through.
I just have to open Box through the internet instead to pull it. Just a second.
Yeah. Okay, that's fine. Okay.
And Stephanie, the one that I'm hoping to pull up is labeled HE301, and then it's got this docket number, and it's COSA CSCCSA 1-2.
Okay, I have that. Just a second. This one does not have a header on it, so you'll need to include a header before I move it over then.
Oh, great. I apologize for that. Okay, I'm ready to go back on the record, and apologies for that, Your Honor.
Okay, we'll go back on the record then.
All right, Mr. Cowan, do you recognize this discovery request that was issued by the solar parties?
We make that a little bit bigger, or I'll probably try. Okay, so we're referring to the Renewable Connect program. Okay.
And
Yes, I do recognize this. Yes.
could we scroll down to the second page? So I see you are listed as the sponsor to this response, at least in part.
Yes, and I'm actually, I make the Renewable Connect filing each year for the update.
Great. Okay. I was just going to ask you if you're familiar with the Renewable Connect program. You answered that
Very
question. Let's level set about this. Do you and I agree that the Renewable Connect program is a subscription service that allows public service customers to offset a portion of their utility bills through that subscription?
Offset or charged, actually. I mean, the the combination of the avoided capacity, avoided credit, or avoided energy credits can sometimes be lower. Excuse me, lower than the charge for the program. So it
Don't need to get into the details. Just at a high level, is it a subscription-based program?
It can go both ways, so it doesn't necessarily offset. So I'm just being clear.
Okay. So it's a subscription program, and do we also agree that it has many similarities to a community solar garden subscription program?
The similarities are few. There are differences in scale, but then also the magnitude of the credit is much smaller than the CSG bill credit by, in some magnitudes, it's maybe a quarter to, a third. So there's some key differences, but in terms of a subscription service to a solar facility, they are similar.
The subscription program, and it's a utility run subscription program. We agree about those things.
We can agree there. Yes.
Okay, great. And we already established you were the sponsor of the response to this request, correct?
One of the two, yes.
I'd like to move to admit this discovery request.
You're gonna have to give it a number.
A hearing exhibit 301, and I'm happy to correct the header. I sincerely apologize. I could do that over the break if that's acceptable.
That's fine. Okay, so any objection to hearing exhibit 301? Hearing none shall be admitted.
All right. So in this discovery request, Mr. Cowan, we asked you some questions about the methodology for the Renewable Connect program. I have a copy of that methodology, which is cited here. Could we scroll back up to the top page? in subsection D, Exhibit 2 to the Renewable Connect filing. Do you recall that question?
Sorry, can you say that again, please?
Sure. Here in this question, we asked you about the Renewable Connect proceeding, 24AL-0487E. And we asked you about exhibits that were filed as a part of that tariff proceeding. Do you recall that? And you see that here?
Yes.
Okay, great. And I have that. If we could go down to Mr. Cowan's answer first. So we had asked you if the company applies an adjustment mechanism in the step 3. There was an objection, but you did say the avoided capacity credit portion of the customer bill credit for Renewable Connect is fixed for the 20-year duration. You recall that answer?
Yes, and I would highlight that here's a difference between what's being proposed by the joint solar parties and the CPI versus what's presented here in Renewable Connect. That amount is predetermined in Renewable Connect, and it's fixed for the life of the program.
Understand. We can get
Difference
into
there, CPI would
Mr.
be
Cowan.
time up. Yeah, there's a difference there.
Mr. Cowan, I interrupt you because I have the methodology up, and I think you can explain your point when we've got that on the screen. But I'd like to
Be
go
happy
ahead
to-
so you have
be
that
happy to.
available. Could we please pull up what has incorrectly also been marked as hearing exhibit 301, but titled 24AL blank exhibit 2?
That one, let me download that one too. Just give me a second.
And Your Honor, while she's doing that, I would be happy to correct that number to 302 while we're on a break, and again, make sure that there's a header.
That's fine. Appreciate that.
Sorry, I messed up.
It's all right. I thought I would have, we're off the record here. I would have figured this would happen during the first one, not the second one.
I know, you think I'd have this down after we're talking about the same thing.
Is this the right one that you wanted?
That is, thank you.
All right, we'll go back on the record now.
So, Mr. Cowan, do you recognize this as Exhibit 2 that we were just talking about in the context of that discovery request?
Yes,
And we agree that this is the derivation of the avoided capacity credit that is applicable in the Renewable Connect program, correct?
and I would specify is the derivation of the fixed avoided capacity credit component to the overall credit.
Great. And this was filed with the commission in that proceeding, correct?
Not only was it filed in the 487 proceeding, but this goes all the way back to 16A0055E and also the 3K settlement. And this is a settled, part of a settled term for what was originally Solar Connect, but then became Renewable Connect. So this is a component of going all the way back to that settlement, that 3K settlement. And this is, again, a fixed component that was negotiated.
You're giving me PTSD for negotiations in room 3C at Excel, but my point here is I'd like to ask to take administrative notice of this document.
What is this document? Just tell me what this document is, basically.
Yes.
I'm happy to explain it.
No,
I mean,
if Mr. Kuster, you can just tell me what you want, what this document is from, or what.
Absolutely. So, to lay a better foundation, there's a similar tariff proceeding, annual tariff proceeding that the company files annually for Renewable Connect. This is the bill credit. This is the avoided capacity credit calculation from that proceeding.
Is that in a proceeding number?
Yes, it's cited in the discovery request that we had up on the screen before. I believe from memory, it's 24AL-0487E, subject to check.
Correct.
Okay, so the avoided capacity calculation from 24AL-0487E, is that correct?
That's correct.
Okay. So is there any objection to taking administrative notice of that?
No objection.
All right, so administrative notice shall be taken of that, and I will not attempt to try and say it again.
Okay, sounds good. Alrighty, Mr. Cowan, let's take a look here at step 3, which is what we asked you about in that discovery request. Looking at line 35, which is a little hard to see, it starts with those words data source. Do we agree that the company explains a 2.8% escalation factor is applied per year, and that's based on the company's construction escalation factor?
I would add, it is, but there's an additional step where
I will
this
get
is
to I
levelized.
promise you I will get to those steps. Do we agree that this, in step 3, this escalation factor is applied?
For those years, yes.
Great. Okay. So, as we go through this document, which I promise we won't spend too much time on, we are going through a stepwise process that the company uses to, again, help calculate that avoided capacity credit, correct?
This is one of the steps, which is this exhibit is presented each year. It's the same numbers, the same value, the same resulting value for the avoided capacity credit.
Great. And so this step 3 is used throughout the remainder of the calculation in different ways. And we can go through those if we want to, but that's my point.
But it's levelized. I think there's a key difference. This component is then levelized in a later step.
But at least in this step, we are applying a 2.8% adjustment factor, correct?
Over those particular years, but it's important that the end value is fixed. That's what's important here.
Okay. Understand that perspective. Here in this step 3, we are applying an adjustment factor.
Yes, I mean, you're taking one component of the calculation, and
Great.
yes, there's an escalator there. Yes.
Okay, great. So I'm running close on my time, so I don't know that we need to spend any more time on this. So if we could please pull this down. So, Mr. Cowan, at the end of the day, do you and I agree that the company does use adjustment mechanisms in other regulatory contexts?
Using the Renewable Connect calculation for the avoided capacity side of the credit, I think we are using them differently. Again, as I pointed out, the end value, the resulting value, the 1.7 cents is fixed for the duration of the program. This is very different from what is being proposed by the joint solar parties, which is a CPI going forward, which can vary between 2, 3, 5% going
Understood.
forward, which has a compounding effect. I think they're vastly different.
Okay.
I mean,
I understand that perspective. Thank you, Mr. Cowan. I have no further questions.
thanks.
All right, Mr. Cowan, I just have one or two questions real quickly. In your opinion, does there have to be a adjustment made to the fixed bill credit in this proceeding?
No.
Okay. And let me ask you, you have gone back before 2025 for some vintages there. Do you believe you needed to do that? And if you didn't, why did you?
The statute's unclear. It's silent on, how far back you go. And, silence doesn't mean allowance to go back, 5, however long. I think we struck a kind of a reasonable balance of, okay, the law went into effect this year. Projects that have been contemplated for that year forward would probably be contemplating the advantage of, having a fixed bill credit for their participants or not. So utilizing 2023 as like the crossover or the effective year, I think, is a reasonable option to select here.
Do you think it's necessary to do that?
No.
Okay, I got nothing further. Any redirect?
We do, Your Honor.
Go right ahead.
Can we first pull up what was previously shown here in Exhibit 102, Mr. Cohen's rebuttal testimony? And would you please go back to page 9? And right here at the top, there were questions with Ms. Kutzer about the statutory language shown on lines 3 through 5. Do you remember that conversation?
Yes.
For the record, could you make clear, please, did the legislature, in your non-attorney perspective, require imposition of an adjustment mechanism?
No.
And if we could look at the language at the end of lines 4 and 5, where it says, through rate adjustments or other mechanisms. Do you see that language?
Yes.
Could you help us provide some testimony about what it means that the other mechanisms references included in statute?
Well, I mean, I'd offer that we provided the commission with a chance to open up an M docket and evaluate bill credits. That's another mechanism. It could be a variety of things, really.
Okay, thank you for that. And then you also talked about Renewable Connect quite a bit with Ms. Kutzer, and you referenced that there are some differences between Renewable Connect and the CSG programs. Are there any specific differences you would like to make clear that you didn't have a chance already to discuss?
I mean, the scale of the resources are very different, and they're procured in different ways. So you have a utility scale, which is Renewable Connect. It's a 50 megawatt facility, procured through RFP. And utility scale tends to, when it's competitively bid, tends to drive down cost of the facility. That's one big difference. The crediting structures are completely different. One is, we have CSGs that are based in net metering policy, which is based on a total aggregate retail rate. And then we have one that's derived through, case law, the proceeding that I mentioned in the settlement, going back to 2016, 2017, that they were derived differently. They are different.
Okay.
And I already mentioned, sorry, I'm going to add on. I already mentioned how, we're isolating one fixed component of the bill credit that is, does have calculations in there that they're levelized, but then the end result, I think this is what truly matters. That's fixed for the duration of the program. It does not change.
I actually would like you to show that on the screen if you don't mind. So can we please reopen here in Exhibit 301? This is the Exhibit 2 from the other proceeding, 24AL-0497E.
Is that the discovery response?
No, it was the first exhibit Ms. Kutzer showed.
I think it's
I
actually
think
the
that's
second one.
302. 302.
Well, yeah,
Oh.
we actually just took
Yeah.
administrative notice of it, but
Yeah, I
My
think
apo-
it'll be it's right now labeled as 301, but it's going to be titled as 302.
You're right. That's my fault. I apologize. So if we could, I know it's probably loading, but here in Exhibit 302 now. And Could you help us find this levelized step you're referring to?
It's later on. It's, I think, step 5.
If we could please scroll down then.
Actually, yeah, it's in step 5. That 7223 is the levelized amount that they derive from that step 3. But then if you please scroll down further, and the point that I'm trying to make, that makes a difference between what's being proposed and what's here. There should be down further, please. All the way down to the bottom. So yeah, avoided capacity credit, 1.769 cents. That value has not changed since 2018. And this program's 20 years. That's going to, again, we file this same exhibit every year. This value is fixed.
You also referenced that this value is predetermined, and that differs from the CPI adjustment proposal put forth by the joint solar parties. Could you please further discuss why this is predetermined and why the rates put forth by the joint solar parties are not?
Yeah, going back to step 3, you have some values that are escalated. Then they're levelized. So that's the predetermined amount right there. And then that's fixed, set right here. What's being proposed by the joint solar parties is a CPI beginning, as I think their proposal is beginning in 2020, and taking CPI, their calculation, and then escalating it from there. So you have a fixed predetermined amount for 20 years of a program, and one that actually is not fixed for the duration of projects in the solar garden program.
So when the commission approved the methodology for Renewable Connect, was it able to determine that the credits and rates are just and reasonable by knowing on a predetermined schedule for each year for the life of the project what the rate would be?
Objection
Yes.
calls for legal conclusion.
Any response?
Yes, just and reasonable is a concept that is heavy in the regulatory practice of which Mr. Cohen is a manager of.
Scripture, you asked, I was waiting for Mr. Mansholt to object to a lot of your questions, which are in the
Fair
same
enough.
world. So I'm going to let that one go.
And to answer the question and to not, they approved this methodology, so it's just and reasonable.
Yeah, but my question though is, in just case I got lost in objections there, was the commission able to know with advanced certainty what each year of the credit would be because the escalation factors were predetermined and known?
Yes.
Okay. Thank you. No further questions on this exhibit here. And you've mentioned a compounding effect in your discussion with Ms. Kutzer. Could you please further describe what you meant by that?
Yes. So, I mean, what's being proposed, my understanding, is use of a CPI that would adjust by a certain percentage, again, pinned to that index, that can vary anywhere from, a percent to 3%, 5% year by year. So if you were to extend this further, you have year 1, say it's theoretically 2%. Year 2, it's another 2%. That's 4%. And if you keep going, I mean, you at the end, over the course of many years, you have many years of 2% or whatever that index is, and it can equal actually a larger amount. So it can compounds.
And has the company undertaken any analysis to consider the impact of that type of compounding effect?
We have.
I would like to open up from box.com, please, what's been pre-marked for identification as hearing exhibit 107.
It's pretty small, so if you tell me the line, I can try and enlarge it.
Sure. If we could please go to the second tab first, the Adjusted Credit Calcs tab.
Mr. Manchel, just looking at the first page of this, I think I know what this is. And I don't think it's the correct version, at least based on what I saw filed on e-filings. The reason I know that is because it starts with 2025. And so it would be helpful to lay a foundation of what this exhibit is.
Could I have an opportunity to do so?
Yeah, I have no idea. You called something up. You got to lay foundation. Go right ahead.
Thank you. Could you, Mr. Cohen, please discuss whether or not this is the analysis the company has undertaken to consider the impact of the compounding effect?
Yes.
And could you discuss with us how you did that type of analysis?
We took
I'm going to object. I think this is a brand new analysis that, there's not a great foundation for. Based on what I saw previously, it appears that this is based on parts of hearing exhibit 300, but it may not be the, correct full version of that. And, it's a brand new spreadsheet the solar parties haven't been able to see. So, I think this is new direct testimony that didn't relate to anything addressed in the cross-examination.
Well, hang on. Right now he's laying foundation, so he hasn't offered it.
Great.
Evidence yet. So, I mean, I don't know what we got. I'll entertain any kind of objection like that if and when he offers it into evidence.
Okay, thank you. And so the question again was, could you, well, first of all, how always start here? Could you discuss with us, for Ms. Kutzer's concerns, what is shown in columns A through G of this tab?
I believe the information that's presented here comes from the Joint Solar Parties witness, Blake Elder, and his testimony regarding what the CPI, their proposal on a CPI would look like. And I believe it captures both, I believe this captures the corrected or the is corrected testimony, but it does show the change in value based on what's been what he presented in his analysis on proposing CPI adjustment.
Just so we're clear, so the A through G is intended to represent exactly the Joint Solar Parties proposal from their revised one here in Exhibit 300 by Mr. Blake Elder.
Yes.
And could you please discuss what is provided in columns L through N?
That's showing the percent change in the rates over time.
Specifically in the first rate discussed, it says 2020 vintage R, and that is cell L1. Can you discuss what rate is being shown here for this, for these years shown for the 2020 vintage R?
Yes, showing the residential rate as adjusted by their mechanism.
And so for years 2020 through 2025, is the information the same as what is shown on the left-hand side of the screen on rows 2 through 7 for the residential rate?
Yes. Or another. I can't see the far left side of the screen. I can't see what R. I can't see columns A, B. Can we shift?
Can you zoom in on your side of the screen, Mr. Cohen?
Okay, yeah. So we have R following column B, because we're looking at the residential credit. That matches column M to 2020, just till 2023. And 2024, yeah, they match. They match.
And then, so what happened after 2025? What did the company do for the years after 2025?
It's just a general assumption about what that index could be, that percentage change could be,
What is the assumption used?
3%.
Could you discuss the basis of using 3%?
I believe the derivation of that comes from, we did listen to the Black Hills hearing, and I believe in the cross-examination of Blake Elder that there was a discussion about in the future what could CPI be, and I believe the discussion was around 3%.
Okay. And so what did the company find by including a 3% change through 2040, a 20-year time frame for the 2020 vintage rate?
Right, and showing the 2020, which that's the joint solar parties want this mechanism to go into effect. Over the course of the 20 years, you in effect have an 85% increase to the bill credit.
If we could scroll down just a little bit, please. Could you discuss whether or not you did a similar process for another vintage of rate?
Yes, this is the 2025 and forward. And less years, and the impact on, the less years equals a lower overall percentage, 51%.
Okay. And just to help wrap this up, let's go to the first tab, the PSCo Solar Rewards Residential tab. Could you discuss whether, or basically what the company did in this tab?
This is graphically depicting what's in those columns of numbers. Going back to 2020, you see in the graphic to the upper right, which has we have some black dashed lines. We have what is actually staff's proposal, which is the orange and green. That's their proposal. But what we're graphically depicting is that, the 2020 through 25, and then the 3% going forward. And then similarly, the next column of rates, the 2025 and on, that blue line represents that column of numbers.
And if we could just scroll to the far left, please, of this tab. So back to column A. Can you discuss what the information in columns A through S represents?
This was staff's proposal on an adjustment mechanism, broadly. Go ahead.
Did the company make any changes to the information provided by staff in columns A through S?
No.
Okay. So with that foundation, the company would seek the introduction of this hearing exhibit 107 based on the fact that it is relevant to assist the commission in what an actual outcome over a full life of a CSG project could be should the commission adopt the proposal set forth by the joint solar parties, of which the company asserts the commission would reasonably want to consider, given these projects exist for 20 years or more.
I'm going to renew my objection with a slight adjustment. I think based on the adjusted credit calcs that we spent some time on, this is in essence rebuttal testimony to Mr. Elder. Mr. Cowan could have presented that, in that rebuttal testimony and chose to not. And this has now gone beyond the scope of my cross-examination.
I'm going to allow it in and stuff. You can have Mr. Elder, if it's incorrect or there's something wrong with that, you can go through that and you can fix that. But I'm going to admit 107.
Thank you. No further questions.
For Mr. Cowan.
Correct.
Okay. Mr. Cowan, thank you very much. Thanks for coming in this morning. Really do appreciate your testimony. And I think you should be good to go for the rest of your day. I don't think anyone's going to recall you. So, again, thank you.
Appreciate it. Thank you for your time, sir.
No problem. All
Your Honor,
right.
might I make two requests before this witness leaves, although I don't know that it's critical to him. One is I believe I have corrected hearing exhibits 301 and 302 in our box.com. They also have headers, so to the extent I need to remove for their introduction, I'd like to do that and make sure they make it in.
Yeah, no, 301's in. The other one is 302. Technically, we took administrative notice of. So
Appreciate that.
So that's it.
I understood that the legal assistant, Stephanie, required the headers to be put on, so those are now in there.
Yeah, okay. No, that's just for the sake of clarity with the headers on. But as far as we're concerned, they're both in.
And then I'd also request to have an executable version of now introduced hearing exhibit 107 available. Is that in the box.com as a whole? I'd like to have Mr. Elder take a look at those calculations so he can verify if their accuracy before he takes the stand.
Mansell?
No objection there. I'm not sure how Box.com can facilitate that or not. If it can't, I'm happy to send the version directly to Ms. Kutzer.
That'd be
The
great.
version that I put into the hearing folder that everyone can access is just the Excel spreadsheet.
Then that is executable so long as Ms. Kutzer's Box.com is working. She should have access. But Ms. Kutzer, if you do not, please just let me know and I can send it to you as well.
Might be quicker if you don't mind dropping a quick email, Mr. Mansholt, just since I'll be occupied with this next witness. Thank you.
And I tell you what, based upon the next witness, I would imagine we're going to take a break after Mr. Thompson. So that would give Mr. Elder give you a little more time to look at that as well too.
And I will let everyone know we are waiving cross-examination on Mr. Thompson based on Mr. Cowan.
Okay. With that, then, do you want to take a break right now? Give Mr. Elder a few minutes to look through that, and I don't think it would take too long. It'd take about 15 minutes.
Your Honor,
And
no concerns of taking a break and giving the joint stock parties enough time that they need. I would mention though that we didn't stipulate to the admission of all of the exhibits listed on 500, which I'm happy to stipulate to. But if we don't, I think I still need to ask Mr. Thompson's exhibits to be entered into the record.
you certainly do. Is there any objection to Mr. Thompson's, which I forget what Mr. Mansholt, do you know what his numbers on his
Yes.
exhibits are?
His testimony is hearing exhibit 101 and the attachments accompanying it, and we would ask that to be entered into the record.
Okay. Is there any objection to that? Okay. 101 attachments shall be admitted. All right. Ms. Kutzer, does that work for you? Ms. Hayden, does that work for you? We take a short break now, say until 10:15. Mr. Elder can take a look through.
Yes.
Yes, Your Honor.
Okay. Mr. Thompson, thank you very much. Sorry you had to sit here, you had to listen to all this, wasted your morning, maybe, I don't know. Made an interesting morning, but I do appreciate you being here. I don't have any questions for you either, so that being the case, you can get on your way. And we shall be in recess until 10:15. Thanks. All right, Harry, still there?
Yes.
Okie dokie. All right, we'll go back on the record with proceeding 24AL-0496E. And I believe it's the solar party's time to call their first witness.
My apologies. I thought we were going to staff next, but we can do that.
I was looking at we can go, whichever you want to do it. I just was looking at the matrix. And I see Mr. Elder next on the matrix. But
I may
doesn't
have
really,
misremembered how we did it last time. I apologize.
no, that's, I'm looking at the matrix. I don't care. Ms. Hayden, were you planning on having Mr. Bongiardino next?
No, I was planning on speaking with Mr. Elder prior
Okay.
to Dr. Bongiardino.
Okay. Yeah, Ms. Kisser, I'm just looking at just going off the matrix.
Yeah, appreciate that. I apologize. I had honestly in my brain switched the cases. Might I have just 1 minute to ensure Mr. Elder's had adequate time to review the exhibit that we just introduced, 107?
Okay, yeah, I'll give you till 10:20. So you have 4 minutes there. So.
Okay.
All
I
right.
don't know if we need that much time, but we'll be right back. Thank you.
Okay. No problem. You all set there?
We are. Thank you, Your Honor.
Okay.
Sorry for that delay.
That's no problem. Okay, hopefully everybody else is back. We'll go back on the record then. As I look for other people to get on. With proceeding 24AL-0497. And now, Mr. Chief, you may call your first witness.
All right, the joint seller parties would like to call Mr. Blake Elder.
All right, Mr. Elder, if you'd raise your right hand for me. You swear affirm, tell the whole truth, nothing but the truth under penalty of perjury.
I do, yes.
All right, good to see you again. Hope your last 2 weeks. Hope you had a nice Memorial Day weekend.
Thank you. You as well.
All right, thank you. All right, Ms. Goochman, go ahead.
All right, Mr. Elder, could you please state and spell your first and last name for the record?
My name is Blake Elder, BlakeElder.
And by whom are you employed and in what capacity?
I am the Senior Manager, Regulatory Manager at the Coalition for Community Solar Access.
And have you caused to be filed what's been pre-marked as hearing exhibit 300 Rev 1 in this proceeding?
Yes, I have.
And just to level set, that is the corrected version of your answer testimony, correct?
Yes.
Your Honor, I'd like to move to admit hearing exhibit 300 Rev 1 and its attachments.
Any objection to 300 Rev 1 and attachments? Not seeing any, it shall be admitted.
With that, Mr. Elder stands available for cross-examination.
All right, and Mr. Hansholt, you can go first.
Thank you. Hello and good morning, Mr. Elder.
Hello, good morning.
Could we please pull up your hearing exhibit 300 revised? And I'm hoping we could pull up the red line version if that one's available. Great. And could we please turn to page 24? And this series of questions is just to understand, make sure the record's clear on the changes you've made to your testimony. The correction you made to your testimony is specifically shown here in the formula below line 2. Is that correct?
That's correct, yes.
And could you just discuss what result that change has?
So as kind of described on line 1 here, what we're doing with this formula is calculating a percent change in an annualized CPI value between what I refer to as the current year, which is the year in which an advice letter is being filed, and the vintage year of the fixed credit. So the erroneous calculation was subtracting the vintage year CPI value from the current year CPI value and dividing that absolute change by the current year, or in other words, the new value. And that is just simply, it was a mistake. It is not how you typically calculate, or what is the calculation for what we typically describe as a percent change. So the correction that was made was replacing the denominator, the CPI of the current year value to the correct version, which is the vintage year value. And the result of that change was flowing through. I believe there's a table on the next page that shows the output of the calculation and the adjusted fixed bill credit values over time. And the result of the calculation was a slight increase to the values that appear on the table on the next page.
Thank you. And could we just turn to page 25? I think you described that well, but even though there's no red line shown here at all for this updated information, these values in fact changed and increased by some value. Is that your testimony?
Yes, that's correct. And my apologies if there wasn't a red line change here. But the easiest way, so just to be clear, all numerical values in the column with the header R moving all the way to the right to the percent change, all of those values had a slight increase across the board as a result of the correction.
Okay, thank you for clearing the record on that. Moving on and discussing your rate adjustment mechanism proposal. Again, you recommend the commission approve a CPI-based adjustment mechanism, correct?
That's correct, yes.
And in a broad sense, CPI measures inflation?
Yes, it's a widely accepted measure of inflation and the change in purchasing power of a monetary amount over a period of time.
Has there been a deflation environment in the last quarter century such that there could be a negative adjustment and application of your mechanism?
I am not aware of any deflationary event like that you're describing.
Do you know, in fact, the last time the country had a negative CPI value?
I do not know.
Would it surprise you to learn that it happened in 1954?
I guess I have no reaction to it. I'll accept that, but I guess it doesn't necessarily surprise me. I'm not sure the cause of that, but I'll accept your date that you put forward.
If we could open up from box.com, what's been pre-marked for identification as hearing exhibit 103, please. And what's being shown here is a web page called the U.S. Inflation Calculator. And this is provided by the Koa News Media Group company. At the beginning of this webpage, you'll see that there is a description of the CPI and what it is used for, which I don't necessarily want to discuss or have a need to discuss. But what I do find helpful is if we go further down this website, past this page as well, there is a listing here of CPI index, CPI-U from 1913 to 2025. And you'll see that on the right-hand side of the screen, in the second to last column, there is a December to December amount change. Or I'm sorry, it's the it's the percentage change for that calendar year. And if we could go to the end of this table, thank you. I guess I would ask you, looking at that second to last column there for recent years, 24, 23, 22, do these values look correct to you?
Yes, I believe so.
Okay. And if we could just slowly scroll up in that column and look for a negative value, let's go ahead and start that exercise. It's my understanding you don't see a negative one until 1954, but if you see a different one, you could let me know.
Mr. Manshall, did you establish, is this for the United States as a whole or for the Denver, Lakewood, Aurora complex used by
Yeah.
Mr. Elder?
Yeah, as a whole. We could stop right there. That's the first negative I saw was 1954. Would you agree that this shows the first negative was in 1954?
Yes, that appears to be what I'm seeing as well. I'll also note that the CPI data that I relied upon in my testimony was pulled directly from the Bureau of Labor Statistics, and I agree that this data looks similar to that, but I'm not familiar with this source. But yes, I agree that 1954, according to this data, would be the first negative.
Okay.
That column.
Thank you. I would ask Your Honor to take this exhibit that is marked as hearing exhibit 103, I believe. Well, actually, let me just double check my number here.
I see 103 up on the tab there.
Yeah, 103 into the administrative record to support just general CPI information among other sources that are in the record as well.
All right, any objection to 103?
No objection.
All right, 103 shall be admitted.
Okay. We're not going to use that exhibit anymore. Thank you. And I would like to go back to Mr. Elder's answer testimony here in exhibit 300, please.
Did you want the red line?
Yeah, either one's fine, actually. And we're going to go to page 17, please. And at the bottom of this page, starting on line 25, you'll see, Mr. Elder, there's a question here that asks about other examples of escalation adjustments. Do you see that question?
I do, yes.
And if we could scroll to the next page, please. Starting on line 1, one of your purported examples in the first sentence listed is the offsite solar program. Is that correct?
That's correct, yes.
And just to ensure the record is clear on this point, the commission approved methodology for calculating the offsite solar program rate does not use an escalation clause for determination of the fixed reasonable charge, correct?
I'm sorry, you said the commission approved methodology?
Correct.
I mean, I would say that within the context of the public service calculation of the offsite net metering program, the company does use escalation factor as part of the fixed reasonable charge that goes into that is ultimately reduced from the bill credit that is provided to offsite net metering customers.
Okay. I would like to open up from box.com, please. It's been pre-marked for identification as hearing exhibit 109. And you'll see that this is the unopposed comprehensive settlement agreement from the proceeding you were just referencing in that portion of your testimony, which was the company's 22 through 25 res plan. Do you see that?
I do, yes.
And can we please turn to page 21? And we're going to look at paragraph 48. Specifically, we're going to look at the second sentence in paragraph 48. Here it says public services offsite credit will be calculated based on the average retail rate for each rate class, less the current year reasonable charge of transmission, distribution, and public benefit riders adjustment clauses. Did I read that correctly?
Yes.
Based on the settlement term, the actual approved methodology does not reflect an escalation clause for the fixed reasonable charge, but the current year cost of such fixed reasonable charges, correct?
Would it be possible to scroll down to see what footnote 8 is referring to on the DSM? I'm sorry, Mr. Mansholt, can you please repeat your question?
Sure. Based on the settlement term we just read through, the approved offsite methodology does not reflect an escalation clause for the fixed reasonable charge, but the current year cost of such fixed reasonable charges, correct?
Yes, that's correct.
Thank you. Having clarified here that the offsite program does not include an escalation clause, would you also agree with me that the company's on-site net metered service program likewise has no escalation factor?
I can't speak to the on-site net metering program. That wasn't something I reviewed as part of this case.
Okay, I'll ask, well, let me first do this. Let me ask this exhibit to be admitted to the record as hearing exhibit 109.
Any objection to 109? Not hearing none, 109 shall be admitted.
And so now I'd like to please open up from box.com. It's been pre-marked as hearing exhibit 110. Do you see, Mr. Elder, that this tariff sheet is entitled the Net Metering Service Schedule NM?
Yes.
And let's scroll to the last page, please.
Your Honor, the witness has, I'm going to object. The witness has already stated that he didn't review the net metering program as a part of his testimony. I think this goes beyond the scope of what he's put forward.
I'm gonna ask what the relevance is of this real quickly too, if you
Sure.
can tell me that.
Certainly, the witness has identified that he hasn't read through the tariff sheet, which is fine, but the commission could take administrative notice of its approved tariffs through the commission's rules, which specifically allow that process. I'm going to ask Your Honor to take administrative notice of this tariff sheet because once you read through it, you'll find that there is no escalation clause in the company's on-site program.
Uh,
No
Again,
objection to administrative notice, Your Honor.
okay, that's fine. Okay, we'll let it go.
Okay.
So we asking for administrative notice right now?
Yes.
Or, okay,
Well, the objection started before I started administrative notice, but yes, that's what I am seeking.
okay, all right. We'll take administrative notice of the net metering tariff sheets.
Okay. No further questions, Your Honor. Thank you.
Okay. All right, Ms. Hayden. There you are.
Yes,
All
sorry
right.
about that.
Go right ahead.
Good morning, Mr. Elder. My name's Jennifer Hayden. I'm an
Good
assistant.
morning again.
Good morning. I'm an assistant attorney general with the Colorado Department of Law. Mr. Elder, no surprises here. You'll recognize some of these questions. Just to clear up on the vintages. You had previously testified that the joint parties are not challenging the bill credit values proposed in the advice letter. Is that right?
That's correct, yes.
And that the joint parties are not seeking to make any changes to the fundamental methodology used to calculate the CSG bill credits?
No, we're not making any recommendations regarding any changes to the way in which a bill credit, fixed bill credit is calculated. We're simply requesting that the nominal value, or yes, the real value of the nominal credits over time be adjusted to recognize the real change in purchasing power of that amount over the lifetime of a subscription.
And additionally, you're here to ask the Commission to adopt fixed bill credits for vintages that predate the House Bill 23-1137 that when it became effective. Is that right?
Yes, in this case, we, I believe, are asking for vintages for 2020, 2021, and 2020, 21, and 2022, I believe.
Okay. All years prior before the law took place. Is that right?
Since 2020, that's correct. 2020 forward.
Okay. Let's see. When it comes to the CPI-U index is the one that you believe is most reasonable. Is that right?
That's correct. The CPI-U, as opposed to the CPI-W, covers the greater amount of the population. I believe it's roughly 90% of the general population is captured within that CPI-U index.
And the CPI-U index specifically omits energy. Is that right?
So the CPI-U series that the joint parties are proposing to use in our methodology, one of the categories is referring to expenditure items. And yes, within that expenditure item category, we're recommending the use of all items less food and energy.
To apply to this energy case, is that right?
That's correct, yes.
No further questions, Your Honor.
Well, okay. Caught me right in the middle of a sip of coffee there. All right. Mr. Elder, these are going to probably sound pretty familiar to you. They're probably pretty similar to what I asked you the last time I saw you. Let me ask you real first up. So Public Service is proposing that vintages should go back to 2023. Does that satisfy what you think should happen? Or do you think it should go back further?
So I do believe that it's appropriate to go back to the 2020 vintage year and move forward to include 2021, 22, 23, 24, and 25. The reason behind that being as we showed in my testimony, there is a significant amount of capacity that has not yet reached its commercial operation within the CS, that is within the CSG program. That under my reading of Rule 3881B, as well as the statute, should be eligible to elect a fixed bill credit option. And under the current tariff proposal, they would be unable to do so because those values do not exist.
And just so I make sure I get it, under your reading of the statute, it should go back to 2020, correct?
Correct. It should go back to any vintage that includes projects that have yet to reach commercial operation.
And if I recall your testimony, also you believe that I'm required to put an adjustment in for these for the fixed rate in this proceeding. Is that correct?
Yes, Your Honor. My reading of the decision C240447 indicates that in this case we'll be determining bill credit vintages, and after the vintages are established at the conclusion of this case, there will be no further opportunity to go back and revisit them in the future. So,
okay.
Yeah.
That's one I want to make. I'll make sure about that one. So you think this is my one and only chance for the 2025 vintage, and I would assume before then, the ones you think I should do before then, to ever have any adjustment on them. Is that correct?
That is my understanding and my opinion. Yes. Once the values are set in this case, they will be set and unable to be revisited or adjusted in the future.
Okay, and that's under the statute or under the rule or under both?
That is under both. Yes, Your Honor.
Okay. All right. Like I said, they're probably pretty familiar questions to you. I do appreciate time. Any redirect?
Just a couple brief questions, Your Honor. Mr. Elder, ALJ Garvey just asked you if the bill credits were unavailable to be adjusted in the future once a decision is made in this case. Is it possible that that was specified in the Commission's decision adopting the fixed bill credit rules?
Yes. As I recall, that decision uses the phrase fixed is fixed to indicate that after we close the book in this proceeding, that we will no longer be able to revisit them at a future date.
Okay, great. Just a couple other questions here. So when you're talking with Mr. Mansholt, he asked you a couple questions about net metering, and understanding you didn't review that tariff. Just want to ask, are you generally familiar with the concept of net metering as a solar professional?
Yes, I have worked in cases before that have addressed residential net metering in particular.
And is it your understanding that in Colorado we have a 1-to-1 retail rate compensation for net metering today?
Yes, that's my understanding.
So under that 1-to-1 regime, if electricity rates go up, is it true that the value of net metering credits also go up?
Yes, the value of the credit would increase at the same amount that the customer's underlying rate is increasing as well.
So even though you're subject to check of the exhibit admitted, an adjustment mechanism isn't contemplated in the tariff book, the value of net metering credits could increase if retail electricity rates also increase.
Yes, that's correct.
Great. Just one last area. So you recall Mr. Mansholt asked you several questions about CPI trends.
Yes.
And he made the point that the United States has generally been in an inflationary environment for most years since 1910. Do you recall that?
Yes.
Can you explain why a bill credit adjustment mechanism is important to be included for subscribers in an inflationary environment?
So the impact of inflation is reducing the purchasing power of a customer's dollar, or in this credit, customer's bill credit over time. So if I think in the example that was used earlier, if we took that 3% general inflation factor and applied that to a 10-cent per kilowatt hour bill credit in today's dollars. If we go 10 years out from now, that inflationary impact will reduce that 10-cent per kilowatt hour bill credit to, I believe it's roughly 7.6 cents per kilowatt hour. Then if you go 20 years out, again, with the 3% inflation, that value of the bill credit is going to be reduced again to, I believe it's roughly 5.5 cents in all in today's dollars. So you're seeing over time that without an adjustment factor, the real value of that customer's bill credit is decreasing significantly as time goes on.
Thank you, Mr. Eller. No further questions.
All right. Mr. Elder, thank you very much again for your time here. We do appreciate your testimony. You're on the East Coast, right?
I am indeed, yes.
So enjoy your time there. It's later there. Go have some lunch. It's a late lunch for you. So but thank you again for your testimony. Really do appreciate it. And you have a great rest of your day. Okay. All right. Ms. Hayden. You may call your witness.
Thank you, Your Honor. Your Honor, staff calls Dr. Bongiardina.
Right. Dr. Bongiardina, would you please raise your right hand for me? Do you swear or affirm to tell the whole truth, nothing but the truth under penalty of perjury?
I do.
All righty. Go right ahead, Ms. Hayden.
Good morning, Dr. Bongiardina. Could you please state and spell your name for the record?
Yes. My name is Nick, N-I-C-K, last name Bongiardina, B-O-N-G-I-A-R-D-I-N-A.
By whom are you employed and in what capacity?
I'm employed by the Colorado Public Utilities Commission as an analyst in the engineering section of trial staff.
Did you cause to be filed in this proceeding what has been marked as Hearing Exhibit 400 and its attachments?
Yes.
And if I ask you those same questions today, would your answers remain the same?
Yes.
Your Honor, staff moves to admit Hearing Exhibit 400 and its attachments and asks that it be entered into the record.
The objection, no objection, 400 shall be admitted.
Thank you. Your Honor, Dr. Bongiardina is available for cross-examination.
All right, Ms. Kutzer, go right ahead.
Thank you, Your Honor. Dr. Bongiardina, it's nice to see you again.
You as well.
All right, I'm going to see if we can be efficient today. Just a couple questions to level set. Do you and I agree that the case that we are talking about today is very similar to the one we talked about 2 weeks ago?
Yes, they're very similar cases.
So as you've heard other witnesses discuss, we agree that for the fixed bill credit, we have two issues of dispute. One is the vintages of the bill credit, and the other is the application of an adjustment methodology to the fixed bill credit over time, correct?
Yes.
And we also agree that the statute applying to investor-owned utilities, specifically 23-1137, is exactly the same in both cases, correct?
Correct.
The rules that apply to investor-owned utilities are also the same in both cases, correct?
Correct.
And you have presented cross-answer testimony on behalf of staff in both cases, correct?
Correct.
And in each of these sets of testimony, in this case marked as Hearing Exhibit 400, you've set forward a potential alternative bill credit adjustment calculation methodology, correct?
Yes.
I would like to turn to what's been pre-marked in box as Hearing Exhibit 303. As we're doing that, Dr. Bongiardina, what I'm pulling up is a transcript from the hearing 2 weeks ago.
There's two. It says, one says full and one says 516 and then the proceeding number.
Yeah, a spoiler alert, I'm only asking to admit Dr. Bongiardina's testimony from last week, so I have truncated that, but I have the full transcript available for authentication if necessary. So we can pull up just the one called Dr. Bongiardina. Dr. Bongiardina, as I said, this is a transcript from the hearing that took place 2 weeks ago. If I were to ask you the same questions I asked you then today, would you have pretty much the same answers?
I believe so, yes.
I would like to move to admit this transcript into the administrative record.
Any objection to 303?
I just make sure I understand, Ms. Coutser. This is not the entirety of the transcript. It's selected portions of the transcript.
Correct. This is just Dr. Bongiardina's testimony. I do have the full transcript available if you'd like to take a look, Mr. Mansholt. I'm happy to admit either, but to be clear, I'm only interested in admitting Dr. Bongiardina's testimony, not any other witness.
Well, from the company standpoint, at least, we would object and ask for the full record to be introduced if we're going to allow the hearing transcript in. 48 pages is quite a bit of what is, I think, a 300-page document. I think we should just go ahead and admit the whole thing.
I'm not quite sure why I want to admit the whole thing. If we're not going to ask any questions about it, just going to clog up the record. If you have no objection to Dr. Bongiardina's testimony, I'll let that in, but I really don't want to put too much more in there. So I guess that's my question to you, Mr. Mansholt. Do you object? Do you object if it's just that part?
Yeah, we object that there is a selection of the transcript of which we don't know what's in these 48 pages or what's been cut out. I'm not present in that proceeding. For the record clarity to provide due process to the company, if we're going to allow the transcript in, we should allow the entirety of the transcript.
I'm just going to allow this part. I'll allow 303 will be entered in, just this portion. I don't need to clog up the record with superfluous testimony, which is quite numerous. So you go ahead.
All right, Dr. Bongiardina, I think this can be a very brief conversation from here on out. I am happy to scroll down and have you establish that this indeed is just the portion of the transcript that is your testimony. If we could maybe go to page 3. And then we see your name and then direct examination by your attorney. Do you see that?
Yes.
And if we could go to the last page. See closing remarks by ALJ Garvey.
Yes.
Your Honor, without admission, I have no further questions.
Okay. Wow. People are getting to me much quicker than I thought you would. And Ms. Cruz, you're very good and pronouncing your 2 weeks of practice has helped with Dr. Bongiardina's last name. So
I tried. I tried hard. We'll get it now that we'll see each other more often, Dr. Bongiardina.
all right. I just have a couple of same sort of thing that you probably heard before. In this, well, we talked about this last time we were all together, but in this one, you have no problem with them going back to earlier vintages. Is that correct?
Correct. Yeah. Going back to 2023 is reasonable to staff for the same reasons the company discussed earlier.
Okay. Which way do you think I should do it? Which way does staff think I should do it? Does staff think I should? I realize you don't have a problem if I do it that way, but which way should I do it? Should I do it where I don't think you want me to go back to 2020, but there's an argument that you think I should either go back to 2023 or I should not go back to 2023. What should I do?
I think it's fair that CSG developers thought they would have access to the fixed credit in 2023. So I think that makes sense.
Okay, so that's what you'd recommend that I do in the case.
Yeah.
Okay, that's fine. It's not a trick question. It's not a trick question. I promise you. And then again, I'll ask you, in your opinion, again, you have a different way for adjustments to occur. Do you think I need to make an adjustment in this case?
I don't think you need to, no.
Do you think this is the only time that I can make an adjustment? Do you think I can do it in a? Do you think next year when these bill credits are for 2026 are being done, that it could possibly be done then or a year after?
So based on my understanding, this could be addressed in the next year's filing or in another proceeding such as the res plan where issues like this are discussed.
Okay. All right. That's all I got. Ms. Hayden, any redirect?
No, nothing from me, Your Honor.
Wow. Okay. All righty then. That is our last witness. I think we're all done. I'll go over real quickly. Here's what I have. All the testimony, of course, is admitted. I have 301. I have the avoided capacity calculation in proceeding 24AL-0487E. Administrative notice is taken to that. 107 was admitted. 103, 109, 303, and then administrative notice of the net metering tariff sheets. If I'm missing something or someone has one they think or wanted to get in, tell me now. Okay. All right. Thank you very much. Thank you, Dr. Bongino. Thank you again. Okay. Thank you fully for that. Thank you for your testimony again. Do appreciate that. Hopefully it wasn't too repetitive for you. Hope you had a good weekend. Hope you have a good weekend now. Is there anything else that anyone has? I'll start with the company. Mr. Manshaw, you got anything more?
No, Your Honor. Just a reminder, the statements of position are due June 12th, and we'll work on that. And thank you so much for an expeditious hearing.
The parties are the ones who make it quick, not me. Hopefully, then I get mad. If I'm making it quick, then I'm mad. You don't want that. So, but I do appreciate all your witnesses, and I appreciate the quick work of everyone today. And 2 issues, it shouldn't be too long. Ms. Kreutzer, you got anything?
I don't. Thank you, Your Honor.
Okay, thank you, Ms. Hayden. You're the last one. Got
Nothing
anything
further,
more?
Your Honor.
All righty then. Okay, thank you very much. Yeah, Mr. Manshaw, you got it the 12th, I think. Is that when the SOPs are due? I look for them. Hopefully, I'm going to have this decision out before the end of June. That's my goal, because I go on vacation the first 2 weeks of July, and I don't want to come back to this. So hopefully, I'll be done by then. So thank you very much. Everybody have a great rest of the week and great weekend. Thanks. We're adjourned.